Hi, good afternoon to all of you tuning in from the East and otherwise welcome. We're really glad to have you wherever you may be signing in from. And we have a very full program today, so I'm going to walk through the details of our agenda momentarily. If you would kindly go to the next slide, please, not Kathy, excuse me, Sophie. Kathy is elsewhere this week, and we have the pleasure of having Sophie helping us. So, Sophie, thank you. Here's what we're going to be covering. In just a few moments, John Riley is going to be hopping on to give us updates on immigration matters. The area is nonstop, as you have seen on preceding webinars. We've been very actively updating you on changes in this space as they relate to your businesses. Tom Iran will be back on the program. You've heard from Tom many times over concerning a quote unquote reverse discrimination case that the Supreme Court recently opined on. Jen Sin will be back on also someone you've heard from many times over on a hospitality issue. There's potential legislation concerning the distribution of alcohol in New York State. Frank Mayer will then follow with a summary from the tax perspective as to what we might expect from the reconciliation bill, which is working its way in Washington, as we've discussed here before. But if Sophie, you go to the next slide, let me talk about the issues of the overnight. The legislature is moving to wrap up here in New York State. We are not quite there yet, but we are getting close. A little bit more activity today. The Assembly has a couple more days now formally scheduled, but things should really close up in terms of activity in the New York State Legislature this week, notwithstanding the special session that we've talked about before that may get scheduled depending on what comes of the reconciliation bill. We just don't know that answer yet. But overnight, medical aid in dying, a bill that has worked its way through the legislature for really the better part of a decade, finally passed both houses, which is a major step in terms of that bill's course, particularly in terms of those who support it. The governor now will have an opportunity to decide whether she indeed supports it as the law in New York. It moves to her desk at some point soon. We talked about the process before. It may not happen until really much later in the year. We just don't know yet, but that it's gotten through both the Assembly and the Senate is a major difference relative to where this legislation has been in previous years. As we look at what else is on for the remainder of the session, we may see some activities around justice policy, criminal justice, environmental legislation. AI is certainly a hot topic, continuing to be. Will the Grieving Families Act get signed by the governor this time? We don't know, though it's likely to get through both houses again. And what will we see in terms of immigration relating language that the New York State Legislature passes, an effort to push back, as it were, on the current federal administration? That's also an unknown, but we may see activity in the close of session. We don't have all those details yet, but in the next 2 weeks or so of the webinar, we will summarize as more material makes its way out from Albany, and we look forward to providing you with those updates. So stay tuned. But for now, let's move briskly to our next presenter. It's John Riley, who is with us from our immigration group to talk about President Trump's issuance of a proclamation restricting entry from 19 countries over what were described as national security and public safety concerns. John, the floor is yours. Thank you.
Thank you, Gabe. Yes, it's another week in immigration law and another presidential proclamation that we're trying to understand and deal with. So, as mentioned last week, President Trump signed a travel ban. This was not unexpected. There was a travel ban in the last administration. It took effect yesterday, and it imposes two kinds of travel entry restrictions, partial and full. So full suspensions apply to the issuance of immigrant visas and non-immigrant visas. So these would be visas issued by a U.S. consulate abroad. And they basically prohibit any kind of visa being issued for countries on this list. And this list includes Afghanistan. I'm just going to read it just so you know. Afghanistan, Iran, Haiti, Burma, Chad, the Republic of Congo, Equatorial Guinea, Eritrea, Libya, Somalia, Sudan, and Yemen. So basically, the administration cited like a high percentage of visa overstays from these countries or national security threats. And they're using this visa ban as a diplomatic tool. So for anybody who is outside of the U.S. and doesn't have a visa, this ban would basically prohibit the issuance of visas for people from those countries. In addition to those 12 countries, there's an additional 7 countries that have a partial ban, and these countries include Venezuela, Burundi, Cuba, Laos, Sierra Leone, Togo, and Turkmenistan. Um, the partial ban blocks specific visa types. Most notably, it's immigrant visas. So this would be a green card, permanent resident card issued abroad at a U.S. consulate, tourist visas, business visas, student and exchange visitors, so students on FMJ visas. It leaves open the possibility of the issuance of non-immigrant visa types like H-1B or L or other visa types. But even in these cases, consular officers have been ordered to kind of be restrictive in their issuance of these. The key points for this travel ban that I think you need to be aware of and that people have asked me about, it does not make anybody currently in the US from these countries deportable. So this ban only applies to entry into the United States or the issue of a visa to enter the United States. This is likely due to the fact that, once a person enters the US, they have due process rights. And prior to that, basically the executive branch can do anything they want in terms of issuing a visa, and those decisions are not really reviewable by a court. So that's probably why it only applies to entry and the issuance of visas. Anybody who's currently in the US with a valid visa who is from one of these 12 countries, it is recommended to not travel during this time in general, because even though the ban does not specifically mention Customs and Border Patrol, um, it does refer to entry into the United States. So, every time a person, goes through a port of entry, they're technically entering the US. So CBP could refuse entry under this ban. It could be interpreted that way. Point number 3 is the ban does not affect change of status or adjustment of status applications for people currently in the US. So if somebody's on a student visa and they want to change to a work visa, this ban does not apply to that. If somebody is in a work visa or student visa and they're applying to become a permanent resident, this ban also does not apply to that. Now, USIS, Department of Homeland Security might start interpreting or being more restrictive for people from these countries, but the ban itself does not apply. There are a few other exceptions. I'll call the NFL, NBA exception. There's exceptions for professional athletes on a case-by-case basis. And kind of general exceptions, it doesn't apply to permanent people who currently have permanent residence status, U.S. government employees, and like certain national interest in humanitarian. So, for example, people who have applied for or will apply for refugee or asylum are not affected by this ban. So the key takeaways are it only applies to a specific list of countries. It only applies to the entry into the United States, doesn't affect people currently here, does not affect adjustment or change of status to different visa category types for people currently here, and there are exceptions. The Trump administration has ordered a review within 90 days to see if countries who are on the list have complied or increased security measures, or I'm sure there's ongoing negotiations with countries like Iran that will affect whether these countries stay on the list and whether other countries get added as well. So that is a quick summary of what the travel ban is, and I will turn the floor back over to Gabe.
And I thank you very much for doing that, John. Let's know that there's more to come on this issue, and we'll have you back for sure. But for now, let's turn to Tom, who is here to tell us about what has happened at the Supreme Court with regard to, again, reverse discrimination, as it is sometimes loosely described. The Supreme Court opined in a way that was at some level unexpected, right, Tom?
Yes, thanks, Gabe. I appreciate you having me on. It's June, and the Supreme Court is wrapping up its term, so we expect to see significant decisions coming from the court. And one of them came out on Thursday. It's the case of Ames against the Ohio Department of Youth Services, where a heterosexual female alleged that she was discriminated against in violation of Title VII based on her sexual orientation. Her allegation was that she was denied a promotion for which she was qualified and also demoted from her position. And then in each case, an individual of a different sexual orientation was awarded the post. And that's fundamentally the basis for her claim. The lower courts, at least in Ohio, had recognized that for a so-called majority group plaintiff, right? Think of a white male, or in this case, a heterosexual claiming sexual orientation discrimination. That plaintiff would need to show something more to show that this was the unusual employer who would be discriminating against the historically favored or majority group. And so they looked for certain background circumstances. For example, proof that the individual who made the decision was within the minority group involved in the dispute, or things of that sort. That case came up to the Supreme Court, and in a decision that was issued by Justice Jackson and was unanimous, 9-0 decision, the court rejected the lower court's analysis. And the Supreme Court, and we can look at this really two ways, right? We can look at sort of the, on its face, the Supreme Court was saying Title VII protects individuals. It does not distinguish by groups. It does not distinguish minority groups from majority groups. It's focused on the individual, and the same legal standard applies. A plaintiff, in order to make out the prima facie case under the well-established McDonnell Douglas framework, needs to show that she suffered an adverse employment action, and in circumstances that give rise to an inference of discrimination. And it's regardless of whether they're in a majority group or a minority group. And you might say, well, okay, we got that message, but in New York, that was the rule already, right? Ohio had this background circumstances, and the Sixth Circuit had the background circumstances rule, which the Supreme Court overruled. But that was not being applied in New York courts or in the courts in the Second Circuit. So why is this significant? And I think it's significant. This is sort of the second level, right? Because of the direction that it's pointing to, right? Step back, and now we're saying, we're almost saying, that it doesn't matter that the plaintiff is in a protected class or not. Not quite there, but close to that. And so the focus lands squarely on the employer's rationale for the decision. And in particular, in terms of the litigation of the case, it's clear to me, at least, that this logic pushes us further along to a jury trial or a bench trial, and takes out of the analysis or reduces the likelihood in the context of the case that the court can decide an issue on a motion, decide it short of going all the way to trial. And that's a significant development as it will play out, that more of these cases will be pushed along to trial and not be decided on motion. And what it means for us, for defense attorneys and for our clients, is that the well-trained manager supervisor who's consistently applying policies that serve a legitimate employer objective are going to become even more important tomorrow than they were yesterday. Because that is going to be the focus of the cases going forward. think that's the lesson to take away from this, Gabe. And we will see as cases develop whether my prognostication proves to be correct.
We shall see, Tom. You often, if not nearly all the time, get it right. So thank you for giving us the preview and for that really helpful summary. And so let's move to Jen. We're stepping back now into New York State. And this we thought was worth a deeper dive because many of you care about the hospitality industry and its various activities. And Jen is always here to update us on them. Jen, what is it that piqued your interest and that you've been tracking?
Yeah, so thank you for having me back. Good to be joining you again. So I'm back today to talk more about the sale of alcohol in New York, specifically the possible sale of wine in supermarkets. So as Gabe mentioned, sometimes I'll come on here and I'll talk about alcohol, and often that's very targeted to our hospitality folks. This is a little bit broader. Honestly, this topic could be interesting to anybody who likes wine. Since the end of Prohibition back in the 30s, New York has not allowed the sale of wine in supermarkets. It's one of about 10 states still in the country that has that prohibition in place. And the possibility of allowing the sale of wine in grocery stores has been discussed many, many years. I've seen bills come up frequently over the years. They never really went anywhere. Now we have a bill pending in New York that seems to be gaining some traction. It's still in committee in both Senate and Assembly, so we'll have to see where it goes. As Gabe mentioned, we're getting down to the wire for the end of the session. But thought this might be a topic that people would be interested in. So there are actually two bills pending, but the one that's getting more traction, it's 1279A Senate bill. And that bill would add a new definition of a supermarket to the alcohol beverage control law. And that supermarket would be a full service grocery store that is primarily engaged in the sale of food. Generally, that's 65% or more of sales from food related items. Already has a license to sell beer and is more than 4,000 square foot. And that definition has come from quite a bit of negotiation. The requirement that 65% of sales come from food it's intended to exclude those national big box retailers and superstores, the ones that sell food, but really are more a general goods retailer that have a very significant buying power. And the square footage requirement of 4,000 square feet, it's intended to ensure that only full service grocery stores included. So not your smaller convenience stores, your gas stations, etc. That definition is important because right now there is already a grocery store license that allows for beer, cider, and wine products. You've maybe seen them in your grocery store in the beer section. That's those sort of beverages that contain wine, but also juice, sugar, carbon dioxide, water, things like that. They have less than 6% alcohol by volume. Your local convenience store, gas station, or drugstore can often qualify for those if they have enough food for sale based on floor space. This would be different if it passes. This would be for your larger supermarkets and would allow them to sell wine being up to 24% alcohol by volume. And it would also allow them to conduct wine tastings. Applicants, again, if this passes, would pay a one-time franchise fee of $10,000 per location. And there'd be an annual fee to maintain the license that would be 0.5% of the total sales of wine in the prior year. And one significant feature that's been a product of negotiation that's now in the bill is that sales of New York wines would not be included in that fee. So that is a incentive for those supermarkets to sell New York State wine. And any fees received annually by the Liquor Authority over $500,000 are going to be transferred to Department of Agriculture and Markets for the specific purpose of promoting New York State wines. So obviously concern here from liquor store owners. There has been some changes to the bill to try to alleviate some of those concerns, proposing to give those liquor store owners the ability to sell some non-alcoholic beverages like mixers, juices, and sodas, sell some glassware, gift baskets, things like that to maybe offset some of these losses. And there are going to be some limitations on location. Again, if the bill passes, wouldn't be able to be issued to a supermarket that is on the same street and within 200 feet of a building occupied exclusively as a school, church, synagogue, or other place of worship. In response to some of those concerns from liquor store owners, the bill was also amended to include a 500-foot rule to make it harder for these licenses to be issued, a supermarket wine license to be issued if it is on the same street and within 500 feet of an existing liquor store. Also added some language that if it is in a larger city and it's within 500 feet of 3 or more other on-premises locations like bars, there's going to be some limitations. In those cases, the applicants would have to get the approval of the municipality or their community board, and there'd have to be a hearing to determine if it's going to be in the public interest. If it does pass, municipalities will be allowed to pass local laws regarding the time, place, and manner of sales under these licenses, but they wouldn't be able to forbid issuance of these wine supermarket licenses. New York Democrats and business leaders gathered actually last week. There's been a fair amount of press coverage. They are advocating for passage of the bill. We will see if it comes up before the session ends, but this has been discussed for many, many years, and something we'll be monitoring.
Jen, thank you for that recap. And we'll see as we move to the close of session whether this ultimately leads to a bill that the governor will have the opportunity to sign. More to come. So thank you very much for giving us a snapshot as to where we are. And we'll turn now to our last speaker for the program, shifting from one side of the Albany office where Jen was to another where Frank is. And Frank, we are thrilled to have you back as always. And I wanted to just remind the audience that Frank will be talking about the federal reconciliation bill, which certainly we have covered here a number of times over, including the possibility that its passage might lead to the New York State legislature coming back later this year to react to it. But Frank has been looking at the bill along with colleagues from the tax perspective, which is his practice's primary footing, and tax is certainly relevant to all of you. So I wanted to make sure that Frank had the opportunity to brief you on what he's seeing. Frank?
Well, Gabe, thank you again for having me back. It's good to be here, and welcome to everyone who's joined us today. So on May 22nd, the U.S. House of Representatives passed the 1,000 plus page tax and spending federal reconciliation bill, H.R. 1, commonly known as the One Big Beautiful Bill Act. Yes, that is the name of the act. The bill, as you probably know from listening to the popular press, has moved to the U.S. Senate. Now, as passed by the House, the bill includes a number of things, but we're going to zero in here today on the particular tax aspects of those things. So, as an initial matter, the bill provides for the exclusion of certain tax provisions enacted under the Tax Cuts and Jobs Act of 2017 under the last Trump administration. Many of the Tax Cuts and Jobs Act's provisions, as you may know, were set to expire on 12/31/25. Under the bill, many of these would now be made permanent. These would include reduced individual tax rates, particularly in the upper income brackets, increased standard deductions, the elimination of the personal exemption, a reduced ceiling on mortgage interest deduction, and the termination of the miscellaneous itemized deduction for individual taxpayers. Now, another key aspect of the bill here is the increased state and local tax deduction, so-called SALT deduction, which is near and dear to many of us in New York who live in high tax states like New York or Connecticut. Basically, the proposals on the table to increase the state and local tax deduction from $10,000 to $40,000 for 2025, with a phase down for amounts with modified adjusted gross income in excess of $500,000. This cap and income threshold will increase 1% per year over the next several years between 2026 and 2023. And quite importantly, the bill closes these SALT cap workarounds in certain states like New York and Connecticut. So let me talk about that. So many times owners of pass-through entities like S corporations and LLC, multi-member LLCs, didn't really have to deal with this $10,000 SALT cap because some state workarounds allowed these organizations to take a deduction at the corporate level or the partnership level for state and local taxes paid by these companies on their members' behalf, their owners' behalf. And while that will remain in place for most businesses, certain so-called specified services business like physicians, accountants, attorneys, financial service firms, and other professional organizations will not be allowed to use this workaround anymore. So it's kind of creating a differential in the treatment of pass-through business entity owners as those that are in certain professions, as opposed to those who may operate other businesses such as construction or real estate development. Another proposal, sort of a breadcrumb thrown at taxpayers, is that there would be a proposal for no taxes on qualified tips or overtime compensation. The bill would allow what's called an above the line deduction, i.e. a deduction for adjusted gross income for tips and OT subject to certain income limitations on overall compensation. Another throwaway is a proposed deduction for automotive loan interest on an automobile loan generated after 12/31/24 for certain passenger vehicles, the final assembly of which occurred in the U.S. subject to certain modified adjusted gross income limits. So taxpayers would not be required to itemize their deduction in order to claim this, and this deduction would expire in 28. It remains to be seen what final assembly vehicles occur in the U.S. will actually mean, because many Hondas are finally manufactured in the U.S., while many Chevrolets, for example, may be manufactured in Canada or Mexico and imported to the U.S. So there will be differential treatment depending on the vehicle. So we'll be interested to see how that plays out. The bill allows for the creation of something called a tax advantage account called Trump accounts. These tax favored accounts for U.S. citizen children born between 1/1/25 and 12/31/28. The accounts will be initially funded with $1,000 of taxpayer dollars, money from the public treasury, and would allow for contributions of up to $5,000 annually to those accounts. Now, at the age of 18 or older, children would be able to withdraw from those funds from those accounts, subject to tax on capital gains rates if used for certain qualified expenses, which include things such as tuition, first-time home purchase, or small business expenses. Other expenses, so-called non-qualified expenses, withdrawal of monies from those accounts would be subject to ordinary income tax rates plus a 10% penalty. Another issue would be the extension of an increase of certain qualified business income deduction, the qualified business income deduction. The qualified business income deduction is something that's available for certain pass-through entities to help get them more in line with the tax rates paid by entities taxed at the corporate level. This was created under the Tax Cuts and Jobs Act when the tax on corporations, C corporations, if you will, was reduced from 35% to 21%. This qualified business income deduction was supposed to expire at 12/31/25. However, it's expected to be made permanent, and the deduction would increase from 20% of qualified business income to 23%. So that would be a little bit more generous for certain business entities. The bill would allow for certain bonus depreciation and increase business interest deduction. How this would work, that manufacturing equipment in particular would be able to be 100% expense between January 19th, 2025 and 12/31/29 to incentivize capital investment. The bill would also allow a more lucrative deduction for interest by allowing interest expense deduction using a concept called EBITDA, earnings before interest, taxes, depreciation, and amortization, allowing a greater interest deduction than previously, which required the use of the interest deduction was limited to earnings before only interest and taxes. So those things are kind of supposedly pro-growth, spur growth type things. Moving away from income tax now to increasing the federal estate tax deduction. The state tax is the tax that's paid on a decedent's estate above a certain threshold. The proposal would be to increase the federal estate tax exclusion to $15 million per estate. Currently, that's at $13,990, and the $15 million would be adjusted for inflation each year. Moving on further, we're talking about termination of various Inflation Reduction Act tax credits enacted under the Inflation Reduction Act during the Biden administration. This would include the repeal of tax credits such as for electric vehicles. You've probably heard a lot about that in the news, and to restrict or provide for an early sunset of other Inflation Reduction Act credits such as clean electricity, fuel, hydrogen production, and investment. Finally, there would be new taxes on private colleges or university endowments, as well as private foundations. So the bill creates a tiered system of taxation based on, for colleges and universities, student adjusted endowment. In other words, the size of the university's or college's endowment as per on a student basis. It creates a tiered tax system between 1.4% and as high as 21% on the institution's net investment income. So the 21% comes into parity with the corporate tax rate. Although this is not going to affect a tremendous amount of colleges and university, it is something that many will need to consider. Finally, and moving right along here, there's an additional tiered tax system on net investment income of private foundations. These are charitable organizations that are not publicly funded, but depending on the size of the private foundation, the net investment income would be taxed at between 1.39% and 10%. Previously, all this income was untaxed. So that's a quick takeaway. And finally, just a moment about where we are as of today. This bill's been kicking around in the Senate since May 22nd, and apparently there's a lot of Senate Republican pushback on increasing the cap, the SALT cap, from $10,000 to $40,000. But there's a lot of push to extend 3 business tax breaks that we talked about: the R&D deduction, the ability to depreciate and amortize interest expensing, and the 100% bonus depreciation, because they are seen as pro-growth. This is sort of done at the expense of things like excluding tax on tips and overtime. And also there's a lot of conflict over repealing those Inflation Reduction Act green energy tax credits as projects are just getting ready to start, and that would upend the economics on many of those projects. So that's a quick overview of this large bill, and I'll send it back to Gabe now. Thank you for listening.
And I thank you, Frank, for that summary on behalf of the audience. And as we learn more about the progression of the reconciliation activities, please do come on back because there'll be more to talk about as we get deeper into the summer, that's for sure. So we've reached our time for today. If Sophie, you'd go to the next slide, please. You'll find everyone's contact information. There it is. And if you have questions for any of the presenters at all, feel free to reach out via email, or you can always contact me, of course. And I look forward to being back with you in 2 weeks' time. Carrie Langan will be your host next Tuesday, and we will have plenty to share as we continue to wind down this very active June. In the meanwhile, be well and have a great afternoon.